This presentation, as you can tell, a lot of people very interested. We had actually scheduled Professor Wallace for a few weeks ago before the Kavanaugh confirmation hearings to give us a look ahead at what a Justice Kavanaugh might bring to the court. And then we thought, you know what, since we had to cancel due to weather on that presentation, we think it's still relevant today to get the professor's view on what could be coming with rulings now that we do have a Justice Kavanaugh on the Supreme Court. So really looking forward to hearing about this. Now, as you may know, Professor Wallace is a friend of the Locke Foundation. He has been here a number of times helping us to understand constitutional law issues. He teaches right across the way at Campbell Law. He teaches constitutional law with a concentration in free speech, church and state, right to arms, and constitutional interpretation. He, of course, has a very impressive resume, all sorts of honors, and he is the author of a number of different pieces. He has won a lot of different awards and highly respected in this community, not only at Campbell Law School, but across the state. That's why we are so delighted to have such access to him to be right across the way from us to come and do these presentations. So without further ado, please join me in welcoming to the podium today Professor Greg Wallace.
Well, thank you so much, Donna, and thank you for the very kind introduction, and thank you to the John Locke Foundation for having me today. I always enjoy coming and speaking with this group here. I've spoken in prior Shaftesbury meetings, and it's always a great group, always has some interesting questions, which I plan to have some time for at the end. I want to talk a little bit today about Justice Kavanaugh and his judicial philosophy, and why the Democrats were so upset and sort of engaged in this scorched earth policy or approach to Kavanaugh's nomination hearing. And then I want to talk a little bit about as well how Justice Kavanaugh may affect the court in the area of the Second Amendment. And we'll try to get to both of those things today. This is a quote from Senator Kamala Harris, who is a Democrat from California. Once Justice Kennedy announced his retirement, she announced on MSNBC, the Chris Matthews show on June the 27th, that anybody that President Trump appoints to the Supreme Court, she said, we're looking at the destruction of the Constitution. Now, she also said later, when Justice Kavanaugh was nominated, that Judge Kavanaugh, then Judge Kavanaugh, was what she called a direct and fundamental threat to the promise of equal justice under the law. Now, I understand that this is, and most people do, that this is just rhetoric, mostly empty rhetoric at that, that is designed to stir up the base, which maybe ought to tell you more about the base than it does about the speaker. But nevertheless, this stuff is not helpful to our conversation about whether Justice Kavanaugh should be on the Supreme Court. And that's really a conversation that frankly has ended at this point, because he does sit on the Supreme Court now. Judge Kavanaugh, now Justice Kavanaugh, is a Yale Law School graduate. He spent 12 years on the United States Court of Appeals for the District of Columbia Circuit. He's written over 300 opinions, so you kind of know where he stands on a number of things. The ABA, which is not typically friendly to the conservative justices, did give him a highly qualified rating, and the president of the ABA tried to tried to come back and retract that later, but he wasn't authorized to do it, and the committee came back and reaffirmed it even after the attempted retraction of that. But Judge Kavanaugh is pretty much, in terms of his judicial philosophy, pretty much a known quantity. His opinions are very carefully reasoned. They are within the mainstream of current legal thought. He has a long track record of supporting free speech, religious freedom, and the Second Amendment rights. He's also a strong proponent of the separation of powers, and he has worked to rein in the vast power of federal administrative agencies. You may not know it, but Kavanaugh either wrote or joined at least 75 different opinions that ruled against the exercise of a certain power by administrative agencies. So he's very committed to separation of powers. I don't think, as some have suggested, that he's going to be a rubber stamp for President Trump's executive orders or executive powers in that regard. So Judge Kavanaugh, I think, stands in the mainstream of conservative judicial thought. Akhil Amar, who is a very well-known law professor at Yale Law School, has written a lot on the Constitution. In fact, one of his best books is entitled The Constitution, a Biography. If you haven't read that, you ought to get that. And he said that President Trump's appointment of now Justice Kavanaugh was President Trump's finest hour and his classiest move. And Professor Amar is not, nobody would consider him conservative in any sense of that term there. But he is a very well-respected constitutional scholar and wrote an op-ed in the New York Times supporting the appointment of Brett Kavanaugh. Now, when we look at Justice Kavanaugh's judicial philosophy, I think there are three things that are important to point out. He's a textualist, he is an originalist, and he is an advocate of judicial restraint. Now, Judge Kavanaugh says that his first duty is to adhere to what the words say. This is something I do with my students in class when I teach constitutional law at the law school right next door here. And my students, by the end of the semester, they always know our starting point is always the text. What does the text say? And Judge Kavanaugh, now Justice Kavanaugh, I'm just going to call him Justice Kavanaugh now, even though I'll be referring to some things that he did while he was Judge Kavanaugh. But Justice Kavanaugh is a committed textualist. He starts with the text and tries to understand first and foremost what the words say. He is also an originalist. Now, there's a lot of confusion, I think, about what originalism is. Some people on the political left now claim to be originalists, and in fact somebody wrote an article in a law review not long ago titled "Everybody's an Originalist Now." Well, I don't think so. Originalists believe that the only authoritative meaning of the Constitution is the ratified meaning, the meaning that was approved by a supermajority vote when the constitutional text was adopted. Now look, you can read the Constitution, I can read the Constitution, the Supreme Court can read the Constitution. But whose meaning controls? Well, the only meaning that has received a supermajority vote, as in required when the Constitution is ratified, the only meaning that has actually been ratified was the meaning that the public attached to the text of the Constitution at the time of ratification. I may say, well, I think the Constitution means this, but the meaning that I propose hasn't been ratified by a 2/3 or 3/4 majority. And the same thing with whatever meaning you attached or whatever meaning any of the law professors over here or our brilliant associate dean, Zeke Bridges, sitting over there, whatever he attaches. So it's the meaning that controls is the one that has been ratified, and that's what originalists hold to. So the originalist judge seeks to understand the meaning that an ordinary reader placed on the Constitution at the time of its enactment. We call this original public meaning. Now, a number of years ago, what we might think of as sort of first-generation originalists, Ed Meese, Robert Bork, they talked about intent, original intent. But no proper originalist that I know today uses that term to describe originalism, because intent is something that's hard to understand. I mean, we're not mind readers. I have a hard enough time understanding my wife's intent about things rather than somebody, you know, that lived more than 200 years ago. So I think that original intent is not the best way to describe originalism. It's actually the original public meaning in that regard. And for originalists, the meaning of the Constitution, that text of the Constitution, was fixed at the time of its adoption, and it establishes the rule of law going forward. Now, of course, that meaning has to be applied to a myriad of modern circumstances, but the meaning itself doesn't change. And this approach is really not radical. It's not extreme. It's, in fact, the way judges typically construe other legal texts. And by the way, the Constitution is a legal text. But it's the way judges construe other legal texts, such as contracts or wills or property deeds. Let's say you enter a contract to buy a parcel of land for $100,000. The contract specifies that you will pay the seller $10,000 a year over 10 years. But in year 5, all of a sudden, the value of the land suddenly increases tenfold. And so the seller takes you to court, claiming that you now owe him a total of $1 million for the land. And he asks the judge to interpret the contract's purchase price according to the value of the land today, not what the language of the contract meant 5 years earlier when you and the seller signed it. Well, the judge would rightly reject the seller's claim on the ground that the contract language means what the parties understood it to mean at the time the contract was signed, not what it should mean 5 years later. And that's, I think, a good illustration of how judges traditionally approach legal text. And as I said, the Constitution is not a living, breathing document that meaning of which changes as the years go by. It's a legal text. And originalism is the practice of trying to understand what the original public meaning of that text is. Now, originalism is not perfect. Scholars and jurists can disagree about the various ways to get to the original meaning of a legal text. There are all sorts of different ways that we can do that. I don't need to go into them now. And originalism doesn't completely eliminate judicial subjectivity. The original meaning cannot be reliably ascertained in every case. And originalism has not always been consistently applied by the judges who espouse it. Still, I think originalism is better than non-originalism to determining the real meaning of the Constitution and restraining what I call judicial mischief. Now, what is this judicial mischief? Well, the reason that the Democrats launched their scorched earth war against Justice Kavanaugh was precisely because his appointment promised a reliable fifth vote for a conservative majority on the court. And that conservative majority believes that believes in the concept of judicial restraint, which by that they mean that judges should rely on text, history, and tradition in constitutional decision-making and not their own political views. The controversial Senate hearings were not about Justice Kavanaugh's past, really. What they were really about is judicial power. And for Democrats and those on the political left, judges really exercise sort of a raw, unchecked political power in determining winners and losers. And it comes down to, for them, judging is about outcomes, not about process. So non-originalist judges, who are sometimes called living constitutionalists, seek to determine the meaning of the Constitution for our time, not what it meant when it was adopted. They believe that judges have the power to change the meaning of constitutional language, to reflect modern values and circumstances. And here's the problem, because there's no consensus on what meaning should replace the original meaning. These judges are free to impose on the rest of us their own personal values and political views under the guise of constitutional decision-making. In short, they can make up constitutional law as they go along. It's sort of like what state common law judges do. They make up the laws of contracts, property, torts as they go along, and certainly checking with precedent, but not being bound by that. And common law rules are judge-made rules. You ask any law student over next door, and I hope the answer they would have, if you know, what is common law judging? Well, it's where judges make the rules. They make the rules of law. And that's very much like what the living constitutionalist type judges do when it comes to constitutional decision making. Now, what happens, the result of this, and why it is something that we all ought to be concerned about, is that this transforms judges into policymakers, and those policies almost always reflect the views of the political left. Non-originalist judges, for example, have expanded powers to advanced statist-type policies. They've devalued constitutional rights essential to liberty, such as free speech, religious freedom, and the right to arms. And they have created rights promoting sexual autonomy, such as abortion and gay marriage, despite those rights not being mentioned in the constitutional text or deeply rooted in our nation's history and tradition. And the big issue for the political left, and this is why the Democrats raised such a fuss over Justice Kavanaugh's nomination, is the preservation of these unenumerated, these so-called unenumerated rights. Now, I happen to believe that the Constitution does protect unenumerated rights. I depart from some of my conservative brethren in that regard. I think the Ninth Amendment is pretty clear about that. The Ninth Amendment talks about the enumeration of these rights should not be construed to deny or disparage the possession of other rights by the people. And if you look at those two words, deny and disparage, first of all, one of the big controversies that occurred between the Federalists and the Anti-Federalists over adding a Bill of Rights, the Federalists said, we don't need a Bill of Rights because how are you going to add, how are you going to come up with a list of all of the important rights that we should add to the Constitution? We're going to miss some, okay? And the Anti-Federalists said, no, well, you know, to identify some is better than none, and they eventually prevailed. They eventually won the day on that issue. But Madison made sure that the Ninth Amendment was in there to say, look, there are other rights that are out there. First of all, by listing the enumerated rights in the Constitution, we don't deny the existence of these other rights. And second, we don't disparage those other rights. In other words, we don't give them somehow, we don't say that they're somehow less important, they're unimportant, They are important. And so the big question, though, for me, and I think for others, is, all right, well, if the Constitution does protect these so-called unenumerated fundamental rights, how do we know what they are? And the Supreme Court has been all over the place with that. But in the Glucksberg case, in a case that where you have at that point 5 conservative justices writing signing on to the opinion in that case, Chief Justice Rehnquist said that the way we know what those fundamental rights, those unenumerated fundamental rights are, is to understand whether they are deeply rooted in our nation's history and tradition and conscience. And the way I look at that, and the way I explain that to my students, is that these are rights about which there has long been a consensus, or virtual consensus, that they are, I'm not talking about unanimity, I'm talking about consensus, most all of the people, but not just a simple majority, but yeah, 80–90% of the people believe that these are rights that are really worth protecting. For example, the Supreme Court has recognized that there's a fundamental right to control the raising and education of your children, for parents to control the education and the raising of their children. I think everybody would agree with that parents have a fundamental right to do that, and the government, can only interfere with that right in extraordinary circumstances. So the question is, are these rights about which there has been a long-standing consensus? Well, if you look at the 2 main rights that the political left is concerned about, the right to abortion and the right to same-sex marriage, neither one of those rights are deeply rooted in our nation's history and tradition. In fact, when Roe versus Wade was decided, you had 100 years of abortion being prevented by state laws. And so even the Supreme Court, in its Roe versus Wade opinion, acknowledged that this was an issue over which people were divided. So there was not a consensus over that. Same thing with gay marriage. You had 31 states at the time the Supreme Court decided Obergefell. You had 31 states that defined marriage as being a relationship between 2 opposite-sex persons. And when the Supreme Court said, well, there's a fundamental right to marriage and it extends to same-sex marriage, there was no consensus about that. That was not a right that was deeply rooted in our history and tradition. And Justice Kennedy in the Obergefell case wrote that, well, okay, we'll give a hat tip to the Glucksberg test, but there are also, we don't need to be confined about, to this one formulation of determining what unenumerated fundamental rights are. We need to be free to devise, to recognize new fundamental rights as our culture demands. And that's just, again, that's very open-ended judicial decision-making, and that's what Justice Kavanaugh disagrees with, and that's why the political left was so adamant about in its opposition to him. Justice Kavanaugh will not destroy the Constitution. In fact, it will be just the opposite. His appointment to the Supreme Court should give greater legitimacy to constitutional decision-making and help move policy-making back to the political branches where it belongs. Perhaps the greatest insight into Judge Kavanaugh's judicial philosophy is found in a 2016 address he gave at the Antonin Scalia School of Law at George Mason University. And he confessed that he considers Justice Scalia to be a hero and a role model. And this is what Justice Kavanaugh said at that time. He said, what did Justice Scalia stand for as a judge? It's not complicated, but it is profound and worth repeating often. The judge's job is to interpret the law, not to make law or policy. So read the words of the statute as written. Read the text of the Constitution as written, mindful of history and tradition. Don't make up new constitutional rights that are not in the text of the Constitution. Don't shy away from enforcing constitutional rights that are in the text of the Constitution. Changing the Constitution is for the amendment process. Changing policy within constitutional bounds is for legislatures. Remember that the structure of the Constitution, the separation of powers, and federalism are not mere matters of etiquette or architecture, but are at least as essential to protecting individual liberty as the individual rights guaranteed in the text. And remember that courts have a critical role when a party has standing in enforcing those separation of powers and federalism limits. Simple but profound. So that, I think, summarizes Justice Kavanaugh's approach to judicial decision-making in that regard. Now, I want to shift just for a moment and talk a little bit about the Second Amendment and why Justice Kavanaugh's appointment to the Supreme Court, I think, is so important with respect to the court's Second Amendment jurisprudence. 10 years ago, the Supreme Court decided the Heller case, and in that case, by a slim 5-4 majority, with Justice Scalia writing the majority opinion for the court, the majority declared that the Second Amendment protects the individual right, not collective right, but individual right to keep and bear arms for lawful purposes, including self-defense. And Justice Scalia did a sort of Herculean job at going back into the nation's history, even prior to the nation going back to the English roots of this concept of self-defense and the right to arms, and put it in that context. Now, Justice Stevens, writing for the majority, I didn't know Justice Stevens was an originalist until we got to the Heller dissent, because he also goes into history of the Second Amendment, and he comes to a different conclusion. He concludes that while the Second Amendment protects an individual right to arms, it only protects it to the extent that the individual is participating in a government-organized militia. And obviously, if you take that interpretation, that narrows the scope of the Second Amendment protections considerably. So 10 years ago, the court decided in Heller that the Second Amendment protects this individual right to keep and bear arms for lawful purposes, including self-defense. The lower courts since that time, as we pointed out in a number of our panels on the Heller's 10th anniversary, I don't know if any of you got to attend that over at the law school back in February, but a number of lower courts have really disregarded, ignored, narrowed Heller in every way possible. It has really not been enforced in the lower courts. They have narrowed Heller to its facts. Heller stands for little beyond handgun bans in the home are unconstitutional, because that's what that was the law that the Heller case addressed there. And so you have court decisions upholding assault weapons bans. You have court decisions upholding good reason requirements for concealed carry, and all sorts of other types of laws. There have just been a few of the lower circuit court cases that have struck down laws, but about 95% of the court cases considering laws under the Second Amendment have upheld those laws even after Heller. And what the lower courts have done is they've developed a two-part test. First of all, they ask, does the Second Amendment apply to this firearm, this conduct, this person? And if it does, then they have to apply some form of heightened scrutiny, either intermediate scrutiny or strict scrutiny from the judicial standpoint. Now, there is a trend currently in lower courts to hold that the Second Amendment doesn't even apply. We saw that in this horrendous decision from the Fourth Circuit 2 years ago in the Colby case, in which the Fourth Circuit held that the AR-15, which is the most popular rifle in America today, is not a protected arm under the Second Amendment. There are some 15 million of them in circulation, but the court said, well, no, it's not a protected arm under the Second Amendment. You have the Peruta case from the Ninth Circuit, where it had held that concealed carry is not a constitutional right. You had the Hamilton case, again from the Fourth Circuit. By the way, most of these cases come from the Ninth and the Fourth Circuit. The Hamilton case, in which the Fourth Circuit, after inviting as-applied challenges to felon disarmament laws, on 3 prior occasions, the Hamilton court said, no, we're not going to entertain any of these as applied, regardless of how the person had rehabilitated, the time, between the felony conviction, if the felony conviction was a nonviolent conviction, etc. And then the Teixeira case, which held that there's no protected right to sell guns. So this is a trend of really stopping the case at the first question here. If the Second Amendment doesn't apply, then you don't even go on to the second element. And even when the courts go on to that second part of the test, they have applied a very soft intermediate scrutiny. Now, intermediate scrutiny is a term we use in constitutional law, which means that the government has the burden of demonstrating that if the law is challenged constitutionally, the government has the burden of demonstrating that it has a significant or important interest behind the law, and that the law itself is narrowly tailored to achieve that interest. Well, what the courts have done is apply a very soft form of intermediate scrutiny, which amounts really to nothing more than saying, well, is this a reasonable law? And the courts almost always conclude that it is. And they have no serious, of course, the government always has an important or compelling interest in public safety. So the key on how this intermediate scrutiny is applied really comes down to, is there a connection, a good, close connection between the means, which is the law itself, and achieving this objective. And the problem is that a lot of the laws that have been upheld are not going to do what they say they do, and yet the courts allow that kind of law to be upheld because they're not really applying any sort of serious means. If you're going to apply a serious means in scrutiny to these types of laws, first of all, there needs to be some evidence that the regulation, the challenge regulation, will in fact be effective. The RAND study, the RAND Corporation just completed a study of studies, came out a 500-page report back in the spring, and it examined a number of the social science studies regarding guns laws and the effectiveness of gun laws. And with assault weapon bans, for example, the RAND study concluded that the evidence is inconclusive that assault weapon bans make any difference in reducing either crime or mass shootings. So there needs to be, in my view, at least some evidence that the regulation will be effective, and it needs to be narrowly tailored so that it will not substantially burden law-abiding citizens. Telling 15 million Americans that you can't own an AR-15 because we've had 8 or 10 people use them in mass shootings is not narrowly tailored. And so what we have to understand is every time you make it more difficult for a bad guy to get a gun, you also make it more difficult for a good guy to get a gun. And these laws, if we're going to apply, I mean, this is a constitutional right. It's not like driving. I've heard people compare, regulating guns to regulating driving. Well, there's no constitutional right to drive. There is a constitutional right to keep and bear arms. Now, the problem is the Supreme Court has not, after Heller, there was a decision 2 years later, the McDonald case, where the court said that the Second Amendment is incorporated against the states through the Due Process Clause. Second Amendment is a fundamental right that's incorporated against the states. But other than one small decision dealing with stun guns, whether stun guns are protected in the Second Amendment, the Supreme Court has not issued any major Second Amendment decision since 2008. That's 10 years. And frankly, the Supreme Court, if the Second Amendment is going to remain vital in our constitutional panoply of rights, then the Supreme Court needs to decide something, needs to issue a new decision on the Second Amendment. Now, Justice Kavanaugh, again, the Democrats, Dianne Feinstein said he's a true Second Amendment radical. Senator Chris Murphy said he was far outside the mainstream of legal thought. Kavanaugh wrote the dissent in Heller 2, which was after the Supreme Court's decision in Heller in 2008. The District of Columbia imposed new gun laws, and the Heller 2 case was a challenge to those. And Judge Kavanaugh wrote the dissent in Heller 2, particularly on the assault weapons ban, and he applied Heller's historical approach and common use test to that assault weapons ban. That's been the major decision that he's written on the Second Amendment, and really what the decision that the Democrats here are concerned about. I think that from reading his decision, studying it, teaching it in my classes, I think Justice Kavanaugh will be a stronger, more reliable Second Amendment vote than Justice Kennedy. Justice Kennedy did vote with the 5-4 majority in the Heller case, but Justice Kennedy, you never could count on his vote in any case almost. And so I think Justice Kavanaugh is going to be a much more reliable vote for Second Amendment rights. I wouldn't be even surprised if the court takes a case. I would like to see the court take an assault weapons ban case. There's one in the First Circuit now that's coming up, in which the district court relied on the Fourth Circuit's decision in Colby to say that AR-15s are not protected under the Second Amendment. But I wouldn't be surprised if Justice Kavanaugh even wrote the majority opinion for the court in that case. And I think there are 5 reliable votes now, unless Justice Roberts goes squishy, that would be for a new Supreme Court Second Amendment decision that would clear up a lot of the disregard and the narrowing that Heller has suffered in the lower court since it was decided. Okay, so I think that's all I have here. I'd like to open it up for questions if you have some. And I'm going to ask you, I'm a little hard of hearing, so if you'll repeat your question loud. And then I'm going to repeat it so that everybody on the video can hear it as well. Yes, yes, sir.
Just quickly, you talked about the Ninth Amendment and the unenumerated rights.
Yes.
I've often thought that the term privileges and immunities encompasses the same group of rights. Do you agree with that or not?
I do, and I teach my students that the Supreme Court was wrong to essentially read the Privileges and Immunities Clause out of the Constitution. I don't know, Justice Thomas had a great argument about that in the McDonald case, which I just mentioned a minute ago. But even Justice Scalia said there's too much water under the bridge. We can't go back and overrule Slaughterhouse and Cruikshank and some of those earlier cases. I don't know. What's happened, though, is I think, at least with respect to the 14th Amendment, these unenumerated rights were understood, privileges and immunities. It's actually privileges or immunities in the 14th Amendment. Or it's privileges and in the earlier in Article, I think 5 or 4 there. But the Privileges or Immunities Clause in the 14th Amendment, so it was understood. If you go back to the statements of Senator Sumter and some of the others that proposed that, they had it was their view that at the very least the Privileges or Immunities Clause incorporated all the rights that were in the Bill of Rights to the Constitution there, and probably more. And I think the Supreme Court was wrong to read that out and then employ a clause that's all about process, not about substance, to do the heavy lifting in that regard. Yes, sir.
What does he feel about precedent? He thinks the case is all decided. How much value is precedent?
Well, he was asked during the confirmation hearing about Roe versus Wade, and he said it was settled law. Okay. Well, settled law can be overturned. The Supreme Court has has, for example, in the Lawrence case, overturned the settled law in the earlier case dealing with homosexual sodomy, and so cases have been overruled. So I think that you have to have a very good reason for overruling cases. I don't think personally that the Supreme Court, with the majority, with the 5-justice majority they have here, I don't look for a reversal of Roe versus Wade. I think what's more likely to happen is that Roe versus Wade will be chipped away around the edges, and the court will allow more restrictions in the way of requirements for doctors that perform abortions and things like this. I think the court, I would be surprised if the court just outright overruled Roe versus Wade. Yes? Yes, I mean the Supreme Court is. You're asking if a change in society's view would change how the court. The Supreme Court. There's an old adage that the Supreme Court follows the headlines of the New York Times, and God help them if they do. But I think the Supreme Court is concerned about, and I think particularly Chief Justice Roberts is concerned about not having the court as an institution be that disruptive in society, and for that reason I think Roberts is an incrementalist. I think any changes that he would want to sign on to would be incremental changes, not a massive overruling of precedent. Yes, sir.
You said that Justice Kavanaugh was a skeptic or was interested in reining in the power of the administrative state.
Yes.
How do you think he would view the judicial power? We had a recent decision where a district court judge determined that the president could not require applicants for entry into the U.S. To come through ports of entry rather than illegally coming across the border. How do you think he would regard that?
Well, the short answer to that is I don't know. I think that he is a believer in separation of powers. But under our laws, if the president is acting pursuant to a statute, then his power, as we learned in the Steele seizure case way back in the 1950s, his power is at the zenith, and the president, if acting, the president has a lot of power constitutionally as the head of the executive branch. So I don't know how Justice Kavanaugh would rule in a case like that. He is skeptic of overreach by the executive branch, I think. So I think he I think he would probably try to. I think the first place he would start would be with the text of the statute, the constitutional cases, precedent in that case. I don't know how he would rule in a case like that. I don't think it's a slam dunk for President Trump, though. Yes?
How do you think the increase in frequency of mass shootings might or ought to have the Supreme Court to recruit a Second Amendment area?
Well, I would first of all quibble with your premise there. I don't think there has been an increase in the number of mass shootings. There have been some very reliable studies done by a number of social scientists that have shown that there has been no real increase in the number of mass shootings, but there has been an increase in the casualty count in the mass shootings that we've had, particularly over the last 5 years. I don't know that really is to be factored into that much into the constitutional analysis of whether there is a right to keep and bear arms with respect to certain types of weapons. I'm doing an article right now working on the lethality of assault weapons. I just published an article on assault weapons myths, which points out a lot of the factual errors in the Colby case and other Federal Circuit Court decisions on assault weapons bans. But now I'm working on assault weapon lethality, and what I'm finding is that, and again, I haven't gotten all this worked out and packaged up in an article yet, but I'm working on it. But my research has shown that the casualty count in mass shootings is really, there's not a direct causal relation to the weapon that is used. There are other factors that are sometimes just as important, if not more important. The shooter's, the strength of the shooter's intention, the proximity of potential victims, the location of the shooter. For example, the Las Vegas shooter was at an elevated location, firing into a densely packed crowd. That obviously increased the casualty count. He could have used, I think he could have used a bolt-action rifle and probably killed as many people in that duration of time that he had to fire. So I think that there are a number of different factors. It's not just a direct causal relation between the weapon and the casualty count there. And I think that more study needs to be done on that. But I think under even a serious form of intermediate scrutiny, to ban the most popular rifle in America simply because it might be one factor in a few shootings is overkill, if you'll pardon the probably not very good pun there, but it's over-inclusive. It sweeps way too broadly. And typically when you're applying heightened scrutiny to constitutional rights, courts don't allow that sort of broad sweep. The law has to be more narrowly tailored to achieving the state's interest in public safety. So I think that I think more study needs to be done on it. My problem with these assault weapons bans is pretty simple. I think that there is no conclusive evidence that shows that assault weapon bans make a significant difference in reducing mass shootings or crime. In fact, rifles are only used in about 3% of the crimes around the country. And I think that, that what we need, what happens in these situations is that oftentimes you have, after a mass shooting with an AR-15, because that fits into the sort of the media narrative and the narrative of the anti-gun groups that want to ban those weapons, then everybody proposes the solution to it is an assault weapons ban. Well, I think the problem with there is that, okay, you can go out and pass an assault weapons ban and pat yourself on the back as doing something, but what you've done, there's no evidence that that is going to have any significant effect on the problem. And what I think that these assault weapon bans do is that they really divert us from doing a deeper investigation into what the real problems are behind mass shooters. And to get into that, you've got to look at things like mental health issues. You've got to look at things like law enforcement failures. There was just an article that I gave my firearms class the other day that was written in one of the Florida newspapers about all the people who failed to prevent the Parkland shooting, and none of them have been held accountable except a few low-level folks there. And you know, I mean, these are the kind of things, hardening targets, these are all the kind of things that we really ought to be looking at. It's a complex problem that is not just addressed by a simple, let's just ban the guns kind of thing. Yes?
I was going to say, wouldn't you say if you're going to ban all assault weapons, then you're just putting them in the hands of people who have them illegally?
Yes, I mean, you look at places where, you know, in California there were assault weapons bans, and yet the people who, the San Bernardino terrorists, got their hands on them. In, I think I'm getting a low battery alert here. In Connecticut, where the shooting was there at Sandy Hook, there was an assault weapons ban there. You look at all the ban. I mean, France has some of the most stringent gun prohibitions anywhere in the world, and yet the terrorists there got weapons. So yeah, I think that's one of the problems with these bans is that they end up affecting the good guys, the 99.9% of the people that don't do that, and really don't have much effect on the 1.1% of the people that do get into that. Yes. Yes, 2 more questions. Yes, sir.
Off guns for a second. Any thoughts about Justice Kavanaugh's feelings about property?
Property rights. I would think that he would be traditionally protective of property rights, but I haven't read any of his opinions dealing with property rights, so I think that any answer that I could give you here would be premature. Yes, sir.
It seems like there's various court cases around the country where the gerrymandering of political classes is moving from racial to party. And I wonder what you might think Justice Kavanaugh might feel about that.
Well, as I explained earlier with Mitch in our interview, partisan gerrymandering was a mess at the court before Justice Kavanaugh ever arrived. A number of years ago, the Supreme Court took a case on partisan gerrymandering, and Justice Kennedy wrote the majority opinion there and just said, man, we can't come up with a workable standard for how much partisanship is too much. And that's the real bugaboo with these types of cases. The Supreme Court had an opportunity last year to decide a couple of cases in partisan gerrymandering. They remanded them on standing grounds. I don't know. I think the big question here is going to be, you know, both parties do it. I mean, partisan gerrymandering, if prostitution is the world's oldest profession, partisan gerrymandering is the second oldest. I mean, both parties have done it for a long, long time. And the big difficulty is a simple one. How do you know where that partisanship crosses the constitutional line there? And you know, I don't know. I don't know how Justice Kavanaugh would rule on that. All right, thank you.